Here we go. Gabriel Smith, a familiar name in this courtroom. But this time, the stakes are higher. What started as a plea deal for 5 years turned into something more serious. Why? Because repeat offenders rarely get another soft pass in Judge West.
Let's do Gabriel Smith. Ms. Malfino, I'll just use your PSI, if that's okay, from the old one. Do you need me to get a copy of it so we can both, I can hand it back and forth? Okay, you're Gabriel Smith, and this is 25 DCCR 0979. There was originally a plea for a cap of 5 years that I rejected. There was a new plea entered of a cap of 8 years, and we reset it for sentencing just for you guys to get anything together that you needed. I did not order an updated report or anything just because she's been in custody. And so is everyone ready to go forward with sentencing?
That's right. I think it's an 8-year cap.
What did I say?
8 years.
Oh, 8-year cap. Yes, I'm sorry. And so, Mr. Kimler, you may proceed.
Your Honor, the court previously refused a 5-year cap, so I'd say the court's probably inclined to give her somewhere between 6 and 8 years on this.
Courtroom. Notice the tone here. Her defense attorney isn't fighting guilt. He's fighting for mercy. This is a common legal tactic when the evidence is overwhelming. The goal? Humanize the defendant before sentencing lands hard. Here's where things...
I think Ms. Smith recognizes the error of what she did. She's attempting to try to remediate that in her own thinking. I understand she is going to have to do some time on this, but I think that she regrets what happened and hopefully not engage in the type of conduct that caused this to occur. It was a theft case that went awry when the officer was attempting to stop her. She didn't really approach the officer and initiate some sort of contact with him. It was, or her. It was an unfortunate incident where, and I'm not contesting her culpability for her guilt, but where the officer reached into the vehicle and the vehicle moved forward, injuring the officer. So obviously, if the court repeats 5, the court's inclined because of her criminal history to go to 6 to 8. We would just argue for 6 at the lower end. I know she has extensive criminal history, but she wanted to address it as well. Is that right? You have to say
I do apologize for the situation that went on, and I wish that anybody that was involved in the case would see that I'm really serious, and to whatever you give me, I thank you for that.
Okay, thank you. Ms. Malfino?
Judge, I think 8 is probably still too low based on the criminal history, but I would agree with Mr. Kimler that the underlying nature of the offense started out as a simple shoplifting case. It obviously went well awry. She could have injured the officer even more so. That being said, in combination with her criminal history, it's not simply just a shoplifting case, and I think she deserves, at the very least,
Turn. Prosecutors love patterns, and Gabriel's record is the pattern. Theft after theft, probation violations, and now an officer injured. What do you think? At what point does second chance lose its meaning?
So, Ms. Smith, the thing is, your theft convictions they start back in, it looks like 2007. And you've got a full page of misdemeanor, well, page and a half of misdemeanor thefts on this pre-sentence report where you were put in the parish jail, and then you proceeded to keep doing it, so they started adding up to felonies. You had probations that were revoked on 4 different theft cases that were misdemeanors that ended up as felonies, that ended up with you going to prison. 5 years was, it looks like you got 5 years in 2016, 3 years in 2017, and then another year in 2018 in prison for the same thing, shoplifting. And this one, you're shoplifting and you end up climbing in your car, and I mean, just what went on with you and that officer is ridiculous, you know, because you're trying to steal again, and now you end up hurting an officer in the process of them trying to stop you from stealing again. I'm going to find that you entered your plea of guilty freely and voluntarily.
This right here is the heart of the sentencing. The judge's words cut deeper than any sentence could. It's not just about stolen goods, it's about stolen trust, both from society and from the justice system itself.
Sufficient evidence to find you guilty, and in cause number 23, DCCR 1034, finds you guilty of robbery, sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you the trial court certification that shows this was an agreement I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Be sure to read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about it or how long it lasts, you can talk with Mr. Kimler.
The wrong case number.
I did.
You went on the robbery, and we actually entered the plea on the assault.
Sorry. 25 DCCR 0979
Right, where's the assault?
finds you guilty of assault. So I will withdraw the finding of guilt on robbery, find you guilty of assault on a peace officer. And all of the rest applies as far as the sentence and the cause number, again, 25 DCCR 0979, correct? Thank you.
I just said on the record, she wanted to make sure it's not aggravated. This is not aggravated.
No, it's non-aggravated.
Okay.
All right. And we have to have that discovery certification today because the case is going to get to close down.
Not again, you never gave it to me.
Well, I mean, when she first pled.
So do I
You didn't give
You
it.
to give me a
still got the credit for me being in here on this?
Yes. All the credit that you were in, any time that you were on this case and there was a hold on you or you were in our custody, you get credit. Okay?
Thank you.
Good luck to you. 8.
This defendant's
Yes.
in the hospital.
Who?
This Robert.
Oh, the defendant. yes.
Defendant is in the hospital.
They're the same.
Okay. Whose is that? So we'll obviously reset Desron Roberts.
He's in the hospital.
Okay. Latrick Williams, let's get him out real quick, please.
Here, this he gets working again, maybe.
Okay. I guess I'll try to plug it in by this time. It's going to be, we'll get it going and then it's going to. Good morning. Are you Latrick Williams? Speak up. And Mr. Williams, it looks like you've got 3 cases, 2 motion to revoke probations, 1 for evading arrest or detention with a vehicle, 1 for theft of a firearm, and then there's a new case that's been indicted for tampering or fabricating physical evidence. And it's my understanding that Ms. Holmes has let me know that your family is going to try to hire an attorney. Is that correct? So are you asking me to reset your case to give your family some time to do that? Okay, so what I will do that. Mr. Williams, I'm sure you have heard, surely, out there by now, that I get copies of these jail incident reports and how you're acting and what you're doing. You think your family knows this when they're going to try to put up some money to go hire you an attorney? Do you think they know how you've been acting out in our jail? Do you?
Whoa, that's not something you usually hear in open court. But Judge West isn't one for sugarcoating. She's using public accountability as a weapon here, exposing behavior that undermines any plea for leniency. It's uncomfortable, and that's...
Do you think they know you've been masturbating in front of the correctional officers out at our jail? Do you think that they know that you're telling them to do their job and you're not going to follow their rules? That you're dashing other inmates with your urine, water, and possibly other items? I would guess other items would probably be something more disgusting than what I've already said, that you're walked up and punched someone in the face so hard that they had to go to EMS, had to come get them. You think they know all that? Should I keep going? Because on those motion to revoke your probations, I don't have to accept any agreement that this lawyer or any lawyer talks to that district attorney about. I don't have to accept an agreement. If I find that you violated your probation, I can sentence you anywhere in the range of punishment. That's what happens when you sign up for probation. If you violate, it's up to me. Sometimes I take deals, sometimes I don't. If you're acting like this, it's very unlikely that you're going to come in and some attorney is going to say, come on, let's give him one more chance. He's a good kid. He's got family. That's great that you've got family, but they don't know how you're acting. And obviously, you're not staying home and doing what you're supposed to while you're on probation. They can only do so much to help you, but you got to grow up and help yourself. If you go to trial on that new case and you're found guilty, a jury will hear all of this. So what's happening out there doesn't stay out there. Everybody finds out about it. And all it does is hurt you. Do you understand? So my suggestion is, the next time you're in court, I don't have a packet this thick of things that you've been doing out at the jail. Because your other attorney, whether it's her or they hire somebody, they're going to have to deal with this. And you can ask anybody. This kind of stuff is not going over well anymore in here. Those people are just trying to go do their jobs every day. They're going to work, going home. They've got families. They don't deserve this. Y'all acting like a bunch of heathens out in the jail? I mean, it's ridiculous, okay? All right, go back with the bailiff. I'll reset the case. Okay, let's see. Mr. Burbank, Devin Byerly, let's see if we can try that again. Oh.
Before we begin, I'll let you know what we've proposed to see.
Okay.
If you even go any further or not.
Okay.
We were here a couple weeks ago on Mr. Byerly. It's my understanding I had previously prepared for a hearing on those new offenses. At that time, the case was reset, so I did not have the officer subpoenaed for today. I can certainly get them if the court would like to hear from those. It's my understanding that he now intends to enter pleas of true to those new offenses. When we were here last, we had semi-made the suggestion of ISF/safety. It came to my understanding that he's already gone to ISF, just from the reaction that the court kind of gave us to that, and in my extensive conversation with Ms. Johnson, we have taken that offer off the table and made an offer of 5 years in all 3 of the felony cases for a revocation, which would then make him a repeat offender if he's back.
Okay. And that's your understanding and your agreement as well, Mr. Burbank?
Yes, Your Honor, and we prepared paperwork and 3 indicated 2 MTRPs in possession.
I only see 2. Is there another set of paperwork? I've got the 2 MTRPs. I don't see the new case. So, we already went through those motions. I guess I just need to go through them again because there's going to be a change of plea.
3, 4, and 6, Your Honor.
Let me, if you'll print the second one, I'll print the first one. Let me get those pulled up real quick just to make it easier for me to go through. And we can print the ones that were already modified. That way I can make notations on that.
And Judge, again, I know I had let you know last time, I'm not meaning to interrupt you.
Go ahead, I'm
while you're
just
reading.
praying.
Obviously, the concern of the original underlying offenses back in 2017 that carried on until 19 was the violation of protective order. I've continued to maintain contact with that family and can assure the court that they have assured me that there has been no issue with Mr. Byerly.
Good.
So
Thank you for that as well.
I just want the record to reflect that.
Okay. I'm getting there. Okay, so,
Would it be better if I made an oral motion to withdraw previous?
nope, I'm just gonna go back and, I'm gonna just rescind everything that we did at the previous hearing, and that way we start fresh from this hearing, and there's no mistake on what everyone's agreement is and what he's pleading true to, and we'll do all of that today. So will he waive the formal reading of the motion and the indictment?
He will, and
The motions. Okay. Mr. Byerly, in cause number 1828800, I have a first amended motion to revoke your unadjudicated probation. It shows that you were placed on probation May 13th of 2019 for the offense of violation of a protective order. That's a third-degree felony, and that was a 10-year deferred probation. Is that correct? And then in cause number 1829063, I also have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 13th of 2019, also for violation of a protective order, a third-degree felony, and that was also a 10-year deferred probation. Is that also correct? And so it alleges that you violated your probation, and y'all are going to go,
1, 2, 3, 4, and 6.
okay. The new offense that he's about to plead is the possession, right?
Correct, that should be number 6.
That's 5.
Oh,
6 is that he possessed it. I mean, but 5 is committed the offense. So that would make
I'm
sense.
sorry, they're different numbers in each one.
Oh,
One is 6
great.
and one is 5.
I love that when that happens.
If you want to amend, Judge, we'll go.
No, it's okay. I have to do, it's the numbers are the numbers. Okay. Count 1 in each of these cases alleges that you violated your probation by committing the offense of assault April 21st of 2025. And is that true or not true?
True.
And then count 2 alleges that you provided a urine sample April 29th of 2025 that tested positive for opiates in each case. Is that true or not true?
True.
2. And then count 3 alleges that you failed to provide verification of attending the JCDI program. Is that true or not true?
True.
And that's in each case as well. Count 4 in each case alleges that you failed to abstain from the use of any and all intoxicating substances, and that you tested positive for alcohol April 15th of 2025. Is that true or not true?
True.
And that's also in both cases. Count 5 in cause number 1829063, and count 6 in cause number 1828800 alleges that you committed the new offense of possession of a controlled substance May 29th of 2025. And is that true or not true? Is that enough for everybody?
Yes, Judge.
Sorry. I feel like I've gotten through it without messing up, but if I keep going on the different numbers. All right. Did you enter your pleas of true in each of those cases freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
In both of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
I understand.
State tenders number 1 in each of those cases. It's admitted in each of those cases. Is there?
That's the point. 3 defendants, 3 very different lessons. Gabriel Smith, the chronic offender who ran out of excuses. Laddick Williams, the inmate whose conduct off the record might decide his future. And Devin Blay, proof that when probation fails, prison waits.
Any evidence that Mr. Byerly is not competent? All right, Mr. Byerly, in each of those motion to revoke your unadjudicated probation cases, I am going to find that you entered your pleas of true freely and voluntarily. And cause number 1829063, find counts 1, 2, 3, 4, and 5 true, find sufficient evidence to find you guilty, and at this time finds you guilty of violation of a protective order, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 18-28800, find counts 1, 2, 3, 4, and 6 true, find sufficient evidence to find you guilty, and at this time find you guilty of violation of a protective order. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Bless you. Okay, now let's go to, okay. Now, Mr. Byerly, in cause number 25, DCCR 0943, you're charged by indictment with a third-degree felony offense of possession of a controlled substance from May 29th of 2025. And how do you plead to that charge? Guilty. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? In that case, I also have here on the computer some documents that have your signature on them. Did you go over these also with Mr. Burbank?
Yes, ma'am.
And do you fully understand them? And you understand if I follow this agreement, you will also be waiving or giving up any right to appeal.
Yes.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in that case. It's admitted. Mr. Byerly, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of this plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 3 cases will all run concurrently, which means together at the same time. I have handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. All right, good luck to you, sir. Thank y'all. Thanks for your patience for me getting through that. Okay. Okay. Mr. LeBlanc, you have a sentencing on Linton R.